shared and heartfelt wishes conveyed. Once again, respectful and profound thanks to you, sir. Now, this is conveyed with this humble presentation. Please accept our token of gratitude, and this is from Sparsh Foundation. On behalf of the entire Sparsh family, Chirag is here to do the honors. ಬಹುಮೌಲ್ಯದ ನುಡಿಗಳನ್ನು, ಅನುಭವಗಳನ್ನು, ಜ್ಞಾನವನ್ನು ನಮ್ಮೊಟ್ಟಿಗೆ ಹಂಚಿಕೊಂಡಿದ್ದಾರೆ. ಶುದ್ಧ ನುಡಿಗಳನ್ನು ಸಾಧನೆ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳು RF Nariman ಸರ್ ಅವರಿಗೆ ಸ್ಪರ್ಶ್ ಫೌಂಡೇಶನ್ ವತಿಯಿಂದ ಈ ಕೃತಜ್ಞತೆಯ ಅರ್ಪಣೆ.
Said he was wrong. The day ended, and the next day, with the grace that only Justice Venkatacharya and he had, Justice Venkatacharya started the proceedings by telling him that as a matter of fact, the bench had not been right. The bench was wrong. And that they ought to have listened to Mr. Patil, and that Mr. Patil's argument was absolutely correct. I have myself also had an experience of a similar kind with Justice Venkatacharya. Justice Venkatacharya was sitting in court number 3 before he became Chief Justice with Justice R.C. Patil, and he had just decided, authoring a judgment for a constitution bench, that expenditure tax was leviable by the union under the residuary entry, because as all of you know, there are 3 lists. We have a union list, we have a state list, we have a concurrent list. And if any matter falls outside any of these lists, including a tax, it will fall within the residuary entry, and a tax can then be imposed by the union. The argument made by our side was that expenditure tax is nothing but a luxury tax, which is covered by entry 62 of the state list. Justice Venkatacharya decided against us, saying that when you take the aspect doctrine, which is something that he borrowed from the Canadian cases, viewed from the expenditure aspect, it would fall under the residuary entry. And viewed from a different luxury aspect, it would fall under entry 62, this too. At that time, the expenditure tax was 10%. Shortly after, Parliament raised it to 20%. And our clients went to court, filed an Article 32 writ petition. And naturally, it was posted before Justice Venkatacharya and, as I told you, Justice Patil. My father led our side research. And I was very keen to show that some aspects of that judgment were not quite correct. And I was hoping that my father would point this out, but he didn't. So as soon as Justice Venkatacharya looked at it and said, "There's very little for you to say now," he agreed and sat down. I must have looked quite aghast because he noticed it. And it is amazing, he called for me. And this time he called for only me. There was a big team, he didn't call for anybody else. At 2 o'clock on the same day. And he said, "I noticed, Mr. Nariman, there was some discomfiture. Was there something that you wanted to say?" So I was young then and I blurted out, I said, "Yes." So he said, "Are you telling us that our judgment is wrong?" So I said, "Yes," in my enthusiasm. And he said, "Oh, please tell us." So I spoke about how I found some passage in Lefroy, Canadian Constitution, and said that when you look at aspects, you have to have an entry versus an entry. You can't have entry versus residual, nothing less. And I also tried to point out that the aspect doctrine was nothing but pith and substance, which is another very well-known doctrine when legislation is challenged as falling within one entry or another. So he immediately recalled the order. He said, "I'm very interested in what you have to tell me. Please give me a written submission on the next occasion and issue notice." Now the next occasion unfortunately never came because Parliament withdrew 20% and it went back to 10%. But I only want to tell you that I had a very similar experience. And it is amazing that any judge would be willing to listen to a junior counsel on how wrong his judgment is. And he was so genuinely interested that he wanted me to give him a written note. Just imagine, these are amazing experiences in one's life. So much for the great Justice Venkatachalaya, whom you all revere. We then come to a very interesting story told of a famous Chola king, Manu Niti Chola. Now, in those days, apparently, he had a bell which any member of the public could ring for instant justice. In this story that it was not rung for some time because justice was meted out all the time. We are also told that after a long time, he gave birth to a son who became the heir apparent, and that the heir apparent grew into a fine man. But ultimately one day, that bell rang again, and this time it rang because a cow stepped on the bell and asked for justice, stating that its calf had been run over by the crown prince. Now, the moment this was brought to the notice of the king to put the crown prince under a particular carriage so that he would also die in the same manner. The famous Hammurabi's code, an eye for an eye, a tooth for a tooth. The minister, of course, refused to do this and committed suicide. Now, having done this, the king himself then said, I have to mete out this justice, and saw that the crown prince was indeed crushed under a chariot. So remorseful was he that he was about to take his own life after that, when the Lord himself came down, saved his life, and brought back all of those who were done away with. So this is one, again, very interesting story. And the statue of this great king, embodying justice of this kind, is outside the Madras High Court. Another famous statue is also spoken of Justice Muthuswami Iyer, who was the first Indian ever to be made a High Court judge. Now imagine, he was made in the year 1877. That year is an amazing year because that is the high noon of the British Raj, of the British Empire. Queen Victoria had reigned as a Queen of England for 40 years and as Empress of India for 20. Lord Lytton was then the Viceroy, one of the strict, difficult English versus native Viceroys. In fact, he was responsible for the Vernacular Press Act of 1878 and the Arms Act, also of 1878, in order to curb native activities. Now, at this point, for an Indian to become a judge of a chartered high court was well nigh impossible. Somehow or the other, this man was such a genius that he was picked up and made a judge. One other very interesting fact is that the Hindu newspaper as we know it today was founded because there were scurrilous attacks against this judge by the Anglo-Indian press. And the Hindu wanted a voice for India to speak up for this great son of India. So this is the other great statue that adorns the Madras High Court which Justice Shivaraj V Patil spoke about. Now, apart from this, there's another very interesting story told about a Chipko movement in the state of Rajasthan. There were some 363 tribals, most of them women, who stuck to a certain tree because it was sought to be cut down by the then ruler, Avaisi of Jodhpur. And mind you, the date was 11 September 1730. There are some dates like this, which I would call Panvati dates in history. Another great Panvati date is 30th January. You will find that not only did the father of our great nation, not only was he martyred on that day, but King Charles I lost his head on that day in 1649. As also, Hitler came to power on that day in 1933. So, 9/11 was the date on which this Chipko movement took place. These poor people were massacred. But then at least after the massacre, the king was most remorseful and promised that he would never ever be ecologically destructive again. So this is one other very interesting matter that Justice Patil adverts to. Among the many judgments that he wrote, one stands out, at least for me, as a constitutional lawyer, the judgment in Ashok Tadwar's case. Now, the question was a seemingly simple question with a seemingly simple answer. It was as to whether under the Consumer Act, whether the Chief Justice of a state had to be consulted in order to appoint the President of the State Commission, whether an acting Chief Justice would fit. Now, this was answered by Justice Patil saying yes. But then he laid down in very felicitous words how we have rejected the doctrine which is called originalism. Now, originalism is a doctrine which has gained some acceptance now in the United States. Seize the Constitution in point of time. Find out what the founding fathers would have said. And if they were clear as to what they were going to say, then that was the end of the matter. And the only way in which you can move forward then is to amend the Constitution. Now, two very interesting quotations are to be found in that judgment. One by the great Justice Jackson in Youngstown Tube Company versus Sawyer, where he specifically says, against originalism, what our forefathers envisaged must be divined from materials almost as enigmatic as those which were the dreams that Joseph was called upon to interpret by Pharaoh. This was one very beautiful quote. And the other was by Dean Roscoe, where he said, please don't construe a constitution as a last will and testament, lest it become one. So this is one of his most outstanding judgments. He then moves on to a very interesting thing that happened at a Johannesburg conference in 2004. He addressed the conference after several judges from the Commonwealth countries had done so. And he told them that in India, even a constitutional amendment can be struck down on substantive as opposed to procedural grounds. And he told them about our great judgment in Keshavananda Bharati's case. It is very, very important to remember that basic structure which is being challenged by some today has come to stay. Some have said that basic structure is today a doctrine with questionable antecedents because it doesn't ground itself in the Constitution. It's completely wrong. Basic structure really emanates from the statements that were made by the Attorney General at that point of time, Mr. Nirinde, and the great Homi Sidhwai, who was then the Advocate General of Maharashtra, appearing for the state of Kerala. When asked, they both made a statement which was recorded by the bench. And the statement was that whatever the word amend means in Article 368, it cannot include a repeal of the Constitution. This is very, very important. Now, moving from there, if it doesn't include a repeal, the immediate question then is, all right, that something of the Constitution has to be left. What is that something? And when we are speaking of a Constitution, we are speaking of a living document which is meant to endure through the ages. So, if there are certain principles which are basic to its existence, which you find in the preamble and elsewhere, for example, the fact that we are a sovereign democratic republic, could it be said that by amendment we cease to be sovereign? We hand back the state, let's say, to the British Crown. Or that we cease to be democratic? We now have a form of government which is totalitarian. Or that we cease to be a republic. In fact, interestingly, one of the examples given by a Heidelberg professor, Peter Conrad, was that, can you say that under the Indian Constitution, you can now revert to monarchy and get rid of an elected president? Dieter Conrad wrote, because the Weimar Constitution was used to destroy itself by Hitler when he came to power. And after World War II, Germany then had a constitution which made it clear that certain basic rights could not be touched by amendment. So this professor argued in 1965 in an article, long before Kesavananda Bharati, that there have to be limitations which one reads into a constitution document, which he called implicit. There are explicit limitations which you find which are procedural limitations under Article 368. But there are implicit limitations which you find with the word amendment. And he came out with 4 stark examples to show that you cannot undermine basic values of the Constitution.
Felicitation from this blessed family. Felicitation to the couple by the organizing committee. This huge garland of roses, conveying all good wishes and seeking blessings. ಹೂವಿನ ದಳಗಳ ಮುಖೇನ ಗೌರವ, ಅಭಿಮಾನ, ಪ್ರೀತಿ, ಸಾರ್ಥಕ್ಯ ಎಲ್ಲವೂ ವ್ಯಕ್ತವಾಗಿದೆ. ಜೆಎಸ್ಎಸ್ ವತಿಯಿಂದ ಸುತ್ತೂರು ಶ್ರೀ ಕ್ಷೇತ್ರ ಮತ್ತು ಜೆಎಸ್ಎಸ್ ಸಮೂಹ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಗಳ ವತಿಯಿಂದಲೂ ಸಹ ಗೌರವ ಸಮರ್ಪಣೆ ಸಾಧ್ಯವಾಗುತ್ತದೆ. ಪರಮ ಪೂಜ್ಯ ಶಿವರಾತ್ರಿ ದೇಶಿಕೇಂದ್ರ ಸ್ವಾಮೀಜಿಯವರು ಈ ಸಂದರ್ಭದಲ್ಲಿ ಉಪಸ್ಥಿತರಿರುತ್ತಿದ್ದು, ಅವರು ಅಯೋಧ್ಯೆಯ ಪೂಜನೀಯ ಕಲಾಪಗಳಲ್ಲಿ ಭಾಗವಹಿಸುವ ಸಲುವಾಗಿ ಅಯೋಧ್ಯೆಗೆ ತೆರಳಿದ್ದಾರೆ. ಹಾಗಾಗಿ ಅವರ ತಂಡ ಇಲ್ಲಿದೆ. ಸುತ್ತೂರು ಮಠದ ವತಿಯಿಂದ ಮತ್ತು ಶಿಕ್ಷಣ ಸಮಿತಿಗಳ ವತಿಯಿಂದ ಪರವಾಗಿ ಈ ಗೌರವ ಸಮರ್ಪಣೆ ದಂಪತಿಗಳಿಗೆ ಸಾಧ್ಯವಾಗ್ತದೆ. And may we request all others who would want to honor and felicitate the couple to please wait till we conclude this function, because ಇದೀಗ ಪೂಜ್ಯ ಸ್ವಾಮೀಜಿ ಅವರ ಆಶೀರ್ವಚನ ನಮಗಾಗಿ ಕಾಗ್ತದೆ. Shivaraj, please be with us. ಸುತ್ತೂರು ಶ್ರೀಗಳು ಖುದ್ದು ಬರಲು ಸಾಧ್ಯವಾಗಿಲ್ಲ, ಆದರೆ ತಮ್ಮ ಶುಭಾಶೀರ್ವಾದವನ್ನು
ಅವರು ಯಾವುದೇ ವಿಚಾರವನ್ನು ಸೂಕ್ಷ್ಮವಾಗಿ ಪರಿಶೀಲಿಸಿ ಆ ಬಗ್ಗೆ ತೀರ್ಮಾನ ನೀಡುವಂತಹ ವಿಶೇಷವಾದ ವ್ಯಕ್ತಿತ್ವವನ್ನು ಹೊಂದಿದ್ದಾರೆ. ಮತ್ತು ಮಾನವೀಯ ಅನುಕಂಪ ಅಂತನ್ನುವುದು ಅವರ ರಕ್ತದ ಕಣಕಣಗಳಲ್ಲಿ ಇರ್ತಕ್ಕಂತಹದ್ದು ಎಲ್ಲರಿಗೂ ಯೋಗ್ಯವಾದಂತಹ ಸಂಗತಿ. ಒಂದು ಗಂಭೀರ ಪ್ರತಿಯೊಂದು ವ್ಯಕ್ತಿ ಕೂಡ ಪ್ರತಿನಿತ್ಯ ಅವರ ಒಂದು ಪುಸ್ತಕದಲ್ಲಿ ಬೇಕಾದಂತಹ